Hello, everyone. Welcome to the stakeholder webinar to discuss EOIR's recently issued final rule titled Recognition of Organizations and Accreditation of Non-Attorney Representatives. I'm Nathan Berkeley of EOIR's Office of Communications and Legislative Affairs. Joining me are Peggy Gleason of EOIR's Office of Legal Access Programs and Paul Rodriguez of EOIR's Office of General Counsel. They will provide a presentation outlining several aspects of the new RNA rule, including the requirements for recognition and accreditation, application and renewal procedures, and oversight and compliance measures. They'll also highlight a number of contrasts between the old and new rule throughout their talk. Once my colleagues conclude their presentation, we will open the remainder of the meeting to your questions, at which time you will be invited to submit questions through the webinar chat function. I'll provide further instructions on submitting questions before the Q&A session begins. I will now turn to Paul Rodriguez to begin the presentation.
Thank you, Nathan. The Executive Office for Immigration Review's Recognition and Accreditation Program addresses the critical and ongoing shortage of qualified legal representation for underserved populations in immigration cases before federal administrative agencies. Through the RNA program, EOIR permits qualified non-attorneys to represent persons before the Department of Homeland Security, the Immigration Courts, and the Board of Immigration Appeals. The specially qualified non-attorneys, known as accredited representatives, must be associated and designated by a nonprofit organization known as a recognized organization. The nonprofit organization must apply to EOIR for its recognition and for the accreditation of its qualified non-lawyers. Currently, there are more than 1,000 recognized organizations and more than 2,000 accredited representatives nationwide. The majority of accredited representatives, approximately 90%, are accredited to appear solely before DHS, and they are known as partially accredited representatives. Approximately 10% of the representatives are accredited to appear before DHS, the Immigration Courts, and the Board, and they are known as fully accredited representatives. As many of the individuals participating in this webinar may know, a rule amending the Recognition and Accreditation program has been in the works for many years. The final rule is a product of our agency's experience administering the program under the current rule through the Board of Immigration Appeals, as well as comments and input from internal and external stakeholders at public meetings and in response to the proposed rule that was issued in October 2015. We are grateful for all the comments we have received, and we believe that the final rule is one that will work for everyone. So now, a few facts about the final rule. It was signed by the Attorney General on December 6, 2016, and it was finally published this past Monday, December 19, 2016. The rule will take effect on January 18, 2017. You can find the rule, you can find a link to the rule from the EOIR website, the homepage. There's a link that will take you to the rule and a PDF version. In the Federal Register, it's found at volume 81, page 92,346. The purpose of this final rule is to promote the effective and efficient administration of justice before DHS and EOIR by increasing the availability of competent non-lawyer representation for underserved immigrant populations, while also protecting the public from fraud and abuse by unscrupulous organizations and individuals. One major change in the final rule is the transfer of the administration of the program from the Board of Immigration Appeals to the Office of Legal Access Programs, otherwise known as OLAP. OLAP is an established administrative program within EOIR whose mission is to manage and oversee programs facilitating access to legal information and representation in immigration proceedings. This transfer from the appellate tribunal of the board to a program manager will allow for less formality and allow for greater engagement with stakeholders, facilitate issuance of guidelines, and promote outreach to increase capacity and to educate the public about attorneys and accredited representatives who are authorized to provide representation in immigration proceedings. And the program can also advise of the dangers of notarios and other fraudsters engaging in the unauthorized practice of immigration law. And now I'm going to turn to Peggy Gleason, who's going to talk about some of the differences and the new additions that will apply to recognized organizations.
Thanks, Paul. Hi, everyone. This is Peggy Gleason from the Office of Legal Access Programs, OLAP, which you'll be hearing a lot of if you're in the recognition and accreditation world from here on out. So I'm going to go over a few things about what a recognized organization needs to be and compare it between the old rule and the new rule. I want to remind you, as Paul just told you, that where you can find the regulation, because that, of course, is the most important authority that you can consult at this point. Among other places, he cited the Federal Register. You can also find it on a link for the invitation to this webinar. If you haven't read it yet, please take a look at that, because that's going to be the most important authority that you can have to figure out what's supposed to happen next. But we're going to give you a few headlines of what that rule says today. So as you know, under the old rule, an organization had to be a nonprofit, religious, charitable, social service, or similar organization established in the United States. Under the new rule, it's very similar. It's a nonprofit, religious, charitable, social service, or similar organization established in the United States. But there's some additional requirements that are explicit in the new rule that weren't in the old rule. Among those are a demonstration of federal tax-exempt status, and I'll talk about what the rule says exactly on how you document that. And in addition, and this is a very important focus of the new rule, what a recognized program needs to be is one that's primarily serving low-income or indigent clients, and that service to that group is very much a key to eligibility for recognition. If the organization charges a fee, it needs to provide fees. It needs to provide a fee waiver policy. And one of the important changes from old rule to new rule is, of course, that there used to be a restriction called the nominal fees, where no fees could be charged that were not considered nominal. That is now eliminated. Instead, the focus on the service that the organization does to low-income and indigent clients, as well as a number of documents that are required to prove that that is what the organization does, is the focus of the rule. A few words about some of those requirements for eligibility that I stated. Under the federal tax-exempt status now, the rule provides various ways that you can prove your tax exemption. Either you have to have a current tax exemption determination letter, or you can provide alternative documentation of tax exemption. In addition, there's a provision that organizations that have applied for tax exemption, federal tax exemption, can show that that request is pending, and they can receive something called conditional recognition, which I'll go into in a little bit. A little bit about the documents that are required to show that you are, in fact, one of those nonprofit, religious, charitable, etc. organizations. There's a whole list of them that you should take a look at. They're in the regulation at 1292.11, number 5, small b, and just to go over them briefly, those organizations include many things that you're familiar with, but a few new ones as well, and I'll probably repeat this as we go through. But you need a copy of the organizing documents of the organization, including a statement of its mission or purpose, a declaration from the authorized officer, and I'll talk about what that is, attesting that it serves primarily low-income and indigent clients, a summary of the legal services to be provided, and if it charges fees for legal services, the fee schedules and organizational policies regarding fee waivers or reduced fees based on need must be provided, and an annual budget. And elsewhere it talks about what an annual budget is that should be provided. In addition, you can provide documentation showing that you serve low-income and indigent individuals in immigration matters, such as reports that have been prepared for funders or information about other low-cost immigration-related services that a program provides, such as educational or outreach events. So those give you an idea of the kinds of things that are being looked for to show that the organization is, in fact, the type of organization that would qualify. All right, so here's another huge change, really, from the old rule to the new rule. The new rule is very much focused on recognition being for organizations that have accredited representatives. That's what recognition is for, And the idea is to have people that are actually meeting the requirements for accreditation that are with a recognized organization so that they can provide additional capacity and additional services. That was not required under the old rules. As you all know, on the roster, the current roster, there's a number of organizations that don't have any accredited reps listed. That's not going to continue indefinitely, and it's not going to be allowed under the new rule, and I'll talk a little bit later about how that's going to change. So the new rule basically is focused on an accredited rep, at least one, being required for certainly for an organization to be recognized in the first instance. It's also required to maintain recognition and to renew recognition. So that's now a requirement. Another big change from old rule to new rule is that under the old rule, to many programs' great inconvenience, they had to apply separately for sublocations of a headquarters office. Under the new rule, there's some specific requirements for it, but it is possible for a primary office to apply for its sub-offices as branch offices in the same application. There's caveats to that. The central office has to basically have an authorized officer who attests that they periodically inspect those sub-offices and that they exercise supervision and control over the accredited representatives in those offices. The idea is that if you have offices that are part of the same management, operations, and funding picture, you should be able to apply for those at the same time. So the hope is that that will make it so much more streamlined for some organizations. Next one. So to repeat, and I'll bring this up again, there's something in the new rule called an authorized officer. And this is important for a number of factors. It provides a primary contact for every recognized organization, which will allow OLAP, the Office of Legal Access Programs, to have one person that they deal with on all matters. That authorized officer is very important because they attest to the truth of the contents of their application, and they are responsible for reporting any kinds of changes and updates to the Office of Legal Access Programs as they might occur after any period of recognition or accreditation of individuals. So that's new. There's an authorized officer. In addition, this is a huge change for the new rules. Once upon a time, under the old rule, it was possible to be recognized indefinitely. And as a result, the roster, unfortunately, has some organizations that are not, in fact, in the business of even attempting immigration legal services anymore. That's not something that anybody wants to continue. Now, recognition, once it's granted under the new rule, will be valid for 6 years. In addition, there's something called conditional recognition. Conditional recognition is for organizations that are new. They've never been recognized before. They will get a 2-year period of recognition, and then they can renew. It's also for organizations that are applying that might have applied for federal tax-exempt status, but it's still pending. In addition, there'll be a 2-year conditional recognition for groups who might have been previously, a recognized group that had previously been terminated and is reapplying. So in some circumstances, it'll be 2 years, but generally, recognition is now for a 6-year period.
So now we're going to turn to some of the changes to from the rule that apply to accreditation. First of all, as I was mentioning earlier about partial and full accreditation, our rule finally now defines partial and full accreditation. So partial accreditation is an accredited representative who can only represent individuals before the Department of Homeland Security. Full accreditation is an individual who can represent individuals before both the Department of Homeland Security and the Immigration Courts and the Board of Immigration Appeals. Another change was that we've shifted from the good moral character requirement of the old rule to a character and fitness requirement. Character and fitness is a more comprehensive examination of the individual seeking to be accredited. It includes the reputation for honesty, trustworthiness, diligence, and reliability. The final rule contemplates that an individual's immigration status may also be considered in the character and fitness determination in certain circumstances. And those circumstances are outlined more fully in the rule, and so I invite you to go look at those. To be an accredited representative, a representative can't be an attorney, cannot be an attorney, cannot be suspended or disbarred or otherwise restricted in the practice of law. This restriction prevents disciplined attorneys from getting around the imposed discipline by seeking accreditation. The rule also requires that the accredited representative be an employee or volunteer of the organization. Like the current rule, the final rule also has a knowledge and experience requirement. The knowledge and experience requirement does not require a minimum number of hours of formal training or testing to provide representation. Rather, an accredited representative just must possess broad knowledge and adequate experience in immigration law and procedure. To satisfy these requirements for partial accreditation, the organization must submit a description of the individual's qualifications, including education and immigration law experience, letters of recommendation from at least 2 persons familiar with the individual's qualifications, and documentation of all relevant formal immigration-related training, including a course on the fundamentals of immigration law, procedure, and practice. For full accreditation, in addition to the other requirements that must be submitted, the organization must also establish that the representative possesses skills for effective litigation at the trial and appellate level. And accreditation, once approved, is also extended to each office or location of a recognized organization where recognition has been extended, which Peggy talked about earlier. And the purpose of this, it will expand service capacity and allows for organizations to extend their recognition to geographically remote or other underserved areas that may otherwise be exploited by unscrupulous individuals.
Okay, and here's a few other things that differ between the old rule and the new rule, just to get into a little bit about the forms. As you know, there have been, for many years, you've been using the EOIR 31 to apply for recognition. There will be a revised version of the EOIR 31. It will be posted by the effective date of January 18th. But in addition now, for accreditation, under the old rule, it wasn't absolutely required that you use the EOIR 31A. It will now be mandatory that you use the EOIR 31A to request accreditation, and that also, of course, will be posted by the effective date for people applying after that time. Some other things about process that will change. The new rule has different service requirements than the old rule did. The old rule required organizations to serve their request for recognition or accreditation on both USCIS, immigration, and Immigrations and Customs Enforcement. That has changed. In the first instance, programs that are applying or individuals that are applying for accreditation only have to serve the Office of USCIS, Immigration. OLAP itself, the Office of Legal Access Programs, has the ability to inquire with Immigrations and Customs Enforcement if they wish to, but this is not something that's going to be required of the applicant. In addition, I just want to point out again that recognition and accreditation are tied together for people applying for initial recognition. So the idea is that you are applying for an accredited rep at the same time you're applying for recognition if it's an initial application. If you're a currently recognized organization without an accredited representative on the effective date of the rule in January, the rule is going to allow a certain time period in which you can hire, train, and seek accreditation for a new representative, and that will have to be done in order for the organization to maintain its place as a recognized organization on the roster. Next one. All right, so a few other things about old rule versus new rule. Supporting documentation, it's somewhat different in the old rule than it is in the new rule, and I'll go over what the new rule requires. You're familiar from the old rule that you had to, for recognition, supply things like your IRS tax document, your charter, your bylaws, and the fee schedule. The list of documents now for recognition, which is found in the rule at 1292.11, letter B, is as follows. Proof for eligibility for recognition includes a copy of the organizing documents, including a statement of mission or purpose, a declaration from the authorized officer, again, who's the person that is the primary point of contact, attesting that the organization serves primarily low-income and indigent clients, a summary of the legal services to be provided, and if fees are charged, fee schedules or policies or guidance on fee waivers or reduced fees have to be supplied, and the annual budget. The annual budget for the current and the prior year, if those exist, has to be supplied. If that's unavailable, the rule says you can give a projected budget for the upcoming year. And then the rule goes on to talk about what a budget basically consists of, and that is operating expenses and sources of revenue have to be detailed, and that includes grants, fees, donations, and dues. In addition, the rule mentions some optional documents. Again, all this is to show what is the nature of this program. Is it primarily serving low-income and indigent clients? If you have reports that have been prepared for other purposes for funders that go into the nature of the organization and the services rendered, if those are relevant, those can be provided, and documentation that show the kind of activities that you do in the community, such as educational and outreach events, those are all helpful. Again, old rule versus new rule. I talked already about what happens in terms of the service. The service now is of your application once it's all prepared is upon USCIS. It used to be on USCIS and ICE. Now the rule says it will be on USCIS. It says that USCIS immigration has 30 days to recommend approval or disapproval. There's also a provision in there that says they can request an extension, and an extension is generally 30 days and not longer, in which to conduct research if they don't have enough time during the initial period. The rule also says that Office of Legal Access programs can request information from Immigration and Customs Enforcement, or it can request additional information from the organization itself. And in other words, there's kind of a request for evidence type of procedure where it can ask for more information. As it was under the old rule, under the new rule, the decision of the Office of Legal Access programs must be in writing.
As Peggy was mentioning earlier, recognition is now no longer indefinite. It will be valid for 6 years, and accreditation is still valid for 3 years as under the current rule as it exists today. In order to renew, recognized organizations must establish that the organization remains eligible for recognition and include fee schedules and an annual summary of immigration legal services provided that the organization compiles since the last approval of recognition, and describe any unreported changes that impact eligibility for recognition from the date of the last approval of recognition. To renew accreditation, the representatives must remain eligible they must meet the requirements for accreditation and have continued to receive formal training in immigration law and procedure commensurate with the services that the organization provides and the duration of the representative's accreditation. Like initial recognition and accreditation application process, OLAP can review the information from USCIS, ICE, EOIR, the EOIR Disciplinary Council, public information, and the organization has the opportunity to respond to any unfavorable information that OLAP may discover. That's the same as in the initial recognition and accreditation process. OLAP's decision to approve or disapprove an organization's renewal of accreditation or recognition is final, provided that a disapproved organization or representative can request reconsideration of a disapproval within 30 days. Peggy also talked about conditional recognition. It's a new feature of the rule. It's primarily for new organizations, but to organizations seeking recognition for the first time, but it also applies to organizations that have been terminated for some reason or who do not have, have applied for federal tax exempt status, but it's still pending. The early renewal period, the 2-year probation, it's a 2-year somewhat probationary period, which allows OLAP greater oversight over the new organizations because they have to come back and renew earlier. The rule also provides new reporting, record keeping, and posting requirements. The duty to report changes is similar to the current rule, however, it's expanded to include a wider variety of things that must be reported to the Office of Legal Access Program. The record-keeping requirement requires that certain tax records, fee schedules, and an annual summary of immigration and legal services provided must be kept for a period of 6 years and must be made available to EOIR or DHS upon request. Those annual summaries and fee schedules will be filed with the renewal request. Under the final rule, there is also a posting requirement. Under this requirement, the OLAP director has the authority to issue public notices that require organizations and representatives to post about organizations and credit representatives, and requires the organizations to post these notices. It will include like the names of the representatives, the approval period of recognition and accreditation, and the means to complain about an organization or representatives. The reporting, record keeping, and posting requirements promote information sharing between OLAP and the organizations, as well as provide an element of oversight. The Office of Legal Access Program regulates the RNA roster, and it may terminate recognition or accreditation for administrative, non-disciplinary reasons. The final rule specifies that the reasons recognition or accreditation may be administratively terminated, such as a failure to renew, losing tax-exempt status. However, the final rule allows for an organization to be placed into inactive status for a period of time to hire a new representative if they were subject to being administratively terminated for not having an accredited representative. An organization whose recognition is terminated or a representative whose accreditation is terminated can request administrative review within 30 days of the initial disapproval in limited circumstances. The final rule additionally adds disciplinary, subjects recognized organizations to formal discipline and sanctions under EOIR's current disciplinary procedures for misconduct, and it provides a process for filing complaints with the EOIR Disciplinary Council regarding organizations, and for the EOIR Disciplinary Council to review those complaints and determine whether formal disciplinary proceedings need to be initiated against an organization. Okay. As I said before, the OLAP's decisions to approve or disapprove a request for recognition or accreditation, or to terminate administratively recognition or accreditation, is final. However, the rule provides in certain circumstances for one request for reconsideration of an adverse decision within 30 days of its issuance. Even after that, the EOIR director has discretionary authority to review a small subset of decisions, negative decisions, adverse decisions, on his or her own initiative if an organization requests so. Yeah.
Okay, so here we're getting to the end here, and we'll take your questions through the instructions that Nathan gives you. But here's a very important piece of information, and this is for organizations that are currently recognized, as well as for individuals that are currently accredited. How are they going to be affected by transition? So I'll go over what the dates are for you of when the organization will have to seek renewal under the new rule. But I would refer you again to the rule itself to take a look at this, and that you'll find this particular section at 8 CFR 1292.16, the letter H and the number 2. And this is what it says. If you are currently recognized, you have to renew under the new rule, and you have to do so either within 1, 2, or 3 years, depending on your particular circumstances. Okay? So the first group that has to renew are organizations that lack an accredited representative on the effective date of the regulation. If that's the case, currently on the roster, there is no accredited representative listed, that organization must, within 1 year, on or before a year of the effective date, apply for renewal. In addition, for other organizations, okay, if you have been recognized more than 10 years as of the effective date of the rule, then you have to apply for renewal under these new provisions within 2 years of the effective date. The last group must apply within 3 years of the effective date, and that is organizations that have been recognized less than 10 years from the effective date of the rule. So it's basically one year for those lacking accredited reps and as of the effective date, and it's 2 or 3 years for everybody else, depending on when you were initially recognized. So take a look at those provisions. Very important that people renew timely, and it can be on or before that deadline. And as Paul pointed out, there are new record-keeping provisions. I suggest that you read those in the new rule as well, because those are going to apply to existing programs as of the effective date of this rule. So as of January 18, 2017, your duty is going to be to keep those kinds of records, because when you apply for renewal, you're supposed to have them. Many of you will have them already, but just to go over them again briefly, take a look at 8 CFR 1292.14, small letter B, and that's where the records that Paul went over, it's everything from the Immigration Legal Services Fee Schedule, the annual summary of legal services provided, etc., must be maintained as of the effective date of the rule. And that's pretty much it. We have a email listed for people who wanted to send in questions after the fact, but I think at this point I'm going to turn it back to Nathan, and he'll deal with questions.
Great, thank you, Peggy. So at this time, we'll turn to your questions. We've already received a number of them, and we'll start working through them. Feel free to submit additional questions via the Questions tab. You'll see that tab below Attendees, below Polls, and Questions is the next tab. Just feel free to enter your question and click Submit or click Send, and we will work through as many of these as we can. Our first question is, how does an organization that serves low-income, how does an organization demonstrate that they serve low-income clients?
Like we were talking about, it's through a variety of documentation. So like your organizing statement, that might include your mission statement and purpose, and it might say, you know, we're focusing on a certain population. That's one way that you can show it. If you're a 501c3 federal tax exempt status, that's also another way that you can demonstrate it. So there's a variety of documentation that you can submit, and then you also have a personal attestation from your authorized officer saying we're focusing on a certain group of individuals.
And just to chime in, the stuff that Paul's talking about is all listed in the rule, so take a look at 1292.11. and that would be under the number 5, small letter B. It says proof of status as a nonprofit, religious, charitable, et cetera, and it gives you a whole list of documents, okay? So that's where the answer to that should be.
And we don't want to like keep telling you go to the rule, but the rule was designed to be very user-friendly. So if you read it, you're gonna know what you need to do. Now, of course, in everything, there's some gray areas, but for the most part, it's an instruction manual for how to apply for recognition and accreditation and how to maintain recognition and accreditation. So it's obviously the best source for what to do. And then if you have, you know, very specific questions, then you can always, you'll be able to contact the Office of Legal Access Programs in the future, and they can help you with those specific questions.
So you just mentioned one of the responsibilities of an authorized officer. The next question is, would you clarify the duties and responsibilities and qualifications of this term authorized officer?
The term authorized officer is defined in the rule. Primarily, it's to serve as the point of contact, and it's supposed to be an individual who can vouch for the submission of a recognition application and the submission of an accreditation application. So they need to be aware of what the organization's purpose is. They're saying we're primarily serving low-income people, so they need to be able to attest this. And in most cases, it's going to be higher-level people in your organization, like the president of an organization. That's generally speaking who it's going to be. But it can be anybody who, as long as they can attest to these, the things that they need to attest to.
Great, thank you. So the next question we received is, how long does a currently recognized organization that does not presently employ an accredited representative have to get someone accredited before the recognition will be terminated?
You want to answer that, Paul? Let me try to answer the first. Before you get to that, the termination, I'll let Paul answer that. But remember, that organization has to apply for renewal within 1 year of the effective date. That's the first thing that has to happen. Then there's an addition provision I'll let Paul talk about, which is the inactive status, which generally will last for 2 years.
Yeah, so I believe the question was directed at an organization, a currently recognized organization without an accredited representative. As Peggy said correctly, that organization needs to apply within 1 year of the January 18th, 2017 effective date. So they have up until January 18th, 2018 to apply for and have accredited a representative. In terms of inactive status, if you're a currently recognized organization and you have accredited representatives on staff, and we get further along down the road, and you lose that accredited representative decides to leave your organization, what the rule will provide is you're not going to lose your recognition immediately, automatically. The rule provides you to go on inactive status, which gives you up to 2 years to find an accredited representative to fill that position. And if your renewal period comes up within that 2-year period, you need to seek renewal, and you can be granted renewal of recognition despite the fact of not having an accredited representative. You're going to have to make representation that you're still looking for an accredited representative and the steps you've taken, and you can be renewed, and you'll be placed again on inactive status for another period of up to 2 years to find an accredited representative. So once you're recognized, there is a very generous provision to allow organizations to maintain their recognition if, for instance, if a accredited representative happens to leave the organization for whatever reason.
So the next question is the posting requirement met by posting materials that will be provided by OLAP? Yes. So what the posting requirement basically allows, it gives OLAP the authority to make materials. That's something that's going to potentially could happen in the future. So it just gives OLAP the authority to do that. And if they decide to do that, then those materials will be distributed to the organizations and they would have to post them at that point. Great, thank you. So the next question I believe you've partially responded to, but I want to allow you a chance to clarify. Will the conditional recognition of 2 years be applied to organizations that are recognized after January 18, 2017, or those that just received recognition in 2016? No, it will be applied to organizations that are recognized after January 18th, 2017. So if you happen to get in before then, you're subject to the renewal requirements of 1, 2, or 3 years that Peggy was talking about at the end of our presentation. If you're somebody who just got in, you would have 3 years, right?
As an accredited rep, yeah.
No, as a newly recognized organization in 2016, you would have 3 years from the date of your recognition.
And now, of course, all that is not something that one has to guess at. It'll be on the roster. You know, what is the date that this recognition expires? Okay, so that'll be clear on the roster itself, where all that will be published.
Just one moment.
Mm-hmm.
If someone has already been accredited but is ineligible under the disciplinary measures that now exist under the new rule, are there retroactive disciplinary measures that would then apply?
Wait, can you repeat that one?
So I believe it's asking if an organization has an accredited representative that if that rep applied now, they wouldn't be eligible.
Mm-hmm.
Does the new rule then make that accredited representative ineligible to count toward the recognized organization's accredited reps?
Well, all representatives that are currently accredited will maintain their recognition as we transfer over to the new rule. Now, they are also subject to the requirements of the new rule once we move over. So if an issue arises where, for instance, the accredited representative happens to get convicted of a crime, that's new information that wasn't available at the time, and the Office of Legal Access Programs can inquire into that, and it could potentially affect that individual's accreditation. So the sort of answer is yes and no, but for purposes of answering your question, everybody who's accredited now maintains their accreditation after January 18th, 2017. Same with all recognized organizations. They maintain their recognition.
Okay, great, thank you. How and when is a recognized organization supposed to notify OLAP of its authorized officer, or to provide information that they indeed have an authorized officer?
So I could take a stab at that. It's on the application, for one thing. You have to name the authorized officer right on the EOIR Form 31, which is, of course, required to apply for recognition or for renewal. So that's required, and in addition, the rule has provisions of a duty to report changes, and those would have to go by notice to, if the authorized officer should change. Of course, the Office of Legal Access needs to know that promptly, but the initial notification would be on the form itself.
Yeah, I don't expect, I mean, organizations could notify the Office of Legal Access Programs on January 19th, 2017, that this person's going to be our authorized officer. The rule doesn't require that. It's when you start submitting forms for recognition, accreditation, renewal of recognition or accreditation, or extension of recognition, where you're going to indicate who your authorized officer is on those forms for the first time in most cases.
Okay, so the next question relates to, it's somewhat technical, related to the submission of annual summaries. The individual writes, it sounds like we're submitting with the form EOIR 31. It also sounds to this individual that they may be required to mail hard copies and not electronically filed, since 6 copies are required. And then the final portion of it is, where do we send these?
Okay. So the annual summary of legal services provided, those are only to be submitted as a general matter at renewal of recognition. So at renewal of recognition, you would have been recognized in most cases, unless you're conditionally recognized, for 6 years. So you would be providing 6 annual summaries of legal services provided. Currently, you would mail those into the Office of Legal Access Programs. The address will be provided on the forms, and it will tell you where to do that. In the future, as the final rule provides, we would like to go to a more electronic system where you can submit your applications via email or other electronic means, however that's set up. So that's how that would be submitted. I think that answers that question.
Yes, and then the very last part of it that I didn't iterate before is, for initial renewal, what additional documents are required in addition to the summaries that we just talked about?
In addition, you would need your fee schedules. If things change between your last renewal or your initial recognition and renewal, you need to submit any documentation that's changed. So if you've changed your fee waiver policy in some way, you should submit a new copy of that. You might have already reported that when you reported a change in how you work. So in that case, you don't need to report it. So if you're already updating OLAP constantly when things change, then you don't need to submit that at renewal. But if there's something that's happened that's different, then you need to submit that at renewal.
Great, thank you. So the next question, it's a why question. It kind of gets to the underlying logic of a particular matter. Why does an organization that has more than 10 years recognition have to renew sooner than one recognized for less than 10 years?
So the logic behind that is that an organization that's been recognized for more than 10 years has not been reviewed in any way for over 10 years. And that doesn't mean that the organization in any way is doing anything wrong. It just means that the board who currently reviews recognition applications hasn't reviewed your application recently. And frankly, the recognition requirements haven't changed that substantially in the new rule that there's a difference, so that new organizations need to be re-reviewed sooner. So that's the underlying logic behind having the greater than 10-year organizations come back sooner for renewal than the less than 10-year organizations.
Great, thank you. So the next question is, so if you're currently accredited, the question is, when do you renew? Do you renew at your BIA given date or at some other date?
So when you get a chance to read the rule and the supplementary information, you'll see that it says that an accredited representative renews at their 3-year mark that the BIA gave them. So if you're coming up on your 3-year deadline, then you're going to be up for renewal of accreditation at that time.
Okay. So the next question relates to relationship between recognition and accreditation under the new rule. For an organization that has been recognized for more than 10 years, will all the accredited representatives within the organization also have to renew within 2 years when the present accreditation is good for 2 years?
Okay, I think I understand the question. No, I think so. Under the final rule, recognition and accreditation are not joined together. They're not linked up. So the renewal periods are not linked up. So the organization, if you've been recognized for more than 10 years, you have to apply for renewal in 2 years. If you're an accredited representative of that organization and you have, for instance, 3 years or a little less than 3 years remaining on your accreditation period, you do not need to seek renewal up until that little less than 3-year mark. So it's they both have different time periods for when they have to seek renewal.
So if an organization opens another office, does that organization still have to apply to get that location recognized?
Okay.
So it's just Peggy Gleason. On extension, again, read the rule on the provision, but you, at the point that you are applying for renewal, you would need to, at that point, include this other office, your sub-office, in your request. Or if you're an initial organization and you're applying now and you meet all the other requirements and you are able to show that you supervise and exercise control over these sub-offices, you could apply for them at the same time. There's a provision on the form itself where you can include them.
Yeah, and it doesn't actually have to happen at initial recognition and renewal recognition. It can also happen if you open an office 1 year into recognition, you open up a new office, you can submit the form. The new forms will just have a spot where you're saying, all I'm seeking is extension of recognition, and then you put down the information, the pertinent information about the new office, so that OLAP is aware. And you're going to want to do that because we will add that to the roster, and so that sub-office will be included on the roster as well.
Okay, so the next question is if an organization has been inactive for over 10 years due to the loss of its accredited representative, does that organization have to apply as a new organization or apply for renewal or apply for renewal as an existing organization? And if recognition and accreditation are granted, will that recognition and accreditation be conditional or valid for 6 years?
Okay, so you're an organization that does not have a currently accredited representative, but you still have maintained your recognition because it's indefinite right now. So you have to do renewal. I mean, that's sort of just that's sort of the process under the rule. You're going to seek renewal, and you must do so within 1 year of the effective date of the rule, and you need to get an accredited representative in order to be renewed. After that, you are going to be subject to the 6 year. You're not going to be conditionally recognized. Conditional recognition only applies to organizations that have not been previously recognized, organizations that have pending tax-exempt status, and organizations that have been terminated or disciplined and are seeking recognition anew.
Okay. So this, the next questioner asks, so they just requested renewal for an accredited representative within the organization or affiliated with it. While waiting for the response, will this organization still be able to receive G28 forms?
I'm not quite sure what they're getting at with the G28 forms, but so an organization has, I'm assuming they've applied to the board to renew the accreditation of their representative, and it's pending right now. So basically what the board is doing now is they're still adjudicating applications, and they will do so until the effective date of the application, effective date of the rule. So your accredited representative may, right now because you applied timely, their accreditation is fine, it will be fine. But if the board does not issue a decision on that renewal request by the effective date, those pending applications will be sent to the Office of Legal Access Programs to adjudicate. And your representative will still be able to continue to practice while the application is pending. And if for some reason the Office of Legal Access Programs reviews the application and says, well, now you're subject to the new rule and we need some additional information, they'll come back to you and ask you for that information. They're not going to say renew it, use a different form or something like that. They're going to ask you we need some additional information. And if they approve the request, then the accredited representative has a new renewal date from 3 years from that date, a new 3-year period, and they can continue on to practice.
Great, thank you. So the next question is, basically, can a county office that offers immigration assistance become recognized?
It is possible that they can get recognized. The rule recognizes that schools, public libraries, and I think it says local governments may be able to show that they are eligible for recognition. They're going to need to show that they're tax exempt, and there is the supplementary information to the rule there's a footnote in there that mentions a letter that you can get from the IRS basically saying we're tax exempt or for schools, libraries, and local governments. But they have to also meet the other requirements of the rule too. It's not just that, so it is possible.
So the next question relates to an organization that's divided into 4 sub-offices. Each has a different recognition date. The organization would want to renew at one time for all 4 offices. Does this organization use the earliest recognition date or the latest, or is there some other way that they need to resolve the matter? Basically, in parens, it says since we fall under both the over 10 years and the under 10, they want to make sure that they
Okay.
do what they're supposed to do.
I think in that situation, well, one of the offices is going to have to be the quote-unquote headquarters office. And if they fall under the we're greater than 10 years old, 10 years, and they're the first ones to be recognized to seek renewal, I would recommend that they seek renewal, and then they also seek renewal for all the other organizations as extensions, if that's the route you're trying to go. So you would have the headquarters office, and then any of the other organizations would be your extended offices. But that's up to your organization if that's the kind of the way you want to be structured.
So related to the last question, if two of the organization's offices have accredited representatives and two do not, will all of the organization's locations be recognized since it's one program with one budget, et cetera?
Okay, that's an interesting question. It's a good hypothetical here. So what I would do in that situation is you're running up against we don't have an accredited rep, we need to get one within a year. So, but if they truly are if they can show that they're an extended office, what you can do is the representatives that do exist in the two offices, and you're seeking, one of those should become the headquarters, and then you're applying for sub-offices. So your accredited representative then can serve all your offices. So in that way, you can say that we provide services at all of these offices. The one issue that might come up is that, are you truly providing immigration legal services at those other two offices? Which you would have to show, and you might have attorneys on staff, I don't know. So that's the only thing I can think of, but it's very possible that you can use the accredited representatives from the offices that have some to provide accredited representatives for the offices that don't have some. So that's possible.
So the next question asks whether an organization needs to maintain documentation of market legal rates along with rate schedules as part of the justification.
No, they don't. If you had them, that would be interesting and something that OLAP wouldn't turn down in trying to determine that. But you're not required to do that. You're not required to have a list of market rates.
So returning to the multiple locations matter for a single organization, this organization is headquartered in New York City with 24 branch offices around the U.S. Though all offices participate in a number of federal grants made to the organization nationally, most offices also receive grants from state or local sources, so each has its own operational budget. Could we request recognition of all offices in a single application?
The rule does not preclude you from doing that. It's probably unlikely that recognition and extension would be granted in that circumstance, unless you can show that there's a headquarters located, there's adequate supervision of the extended locations. It seems in that the purpose of the extension provision primarily is sort of a regional extension. So, for instance, in the D.C. area, if you had an office in Washington, D.C., and then another office in Arlington, Virginia, and another office in Rockville, Maryland, those are all fairly close, and they're closely connected, and the accredited representatives could be going to each of those offices. That's kind of the typical extension of recognition situation. I'm not going to foreclose that a more national organization could seek extension of recognition on a larger scale, but I think it would be the exception, not the rule. It would be, you'd have to make a showing that you can meet the requirements for extension.
And I'd pipe up that you'll see those requirements at 1292.15, and you'll see it talks about supervision and control. which is where you might fall down in trying to go across the country. You've got to show that the authorized officer periodically conducts inspections of each office, and you also have to show that the subordinate office shares management structure, funding sources, etc. So anyway, take a look at 1292.15. That's where that's described.
Okay, when does the Office of Legal Access Programs anticipate updating the roster to reflect the new renewal dates after January 18th of 2017?
Soon.
Yeah, that's yes, very soon. As soon as they can, I think. And I think part of the changeover from the Board of Immigration Appeals to the Office of Legal Access Programs, as we kind of discussed in the presentation, is that the Office of Legal Access Programs has plenty of outreach activities that they do, and they're going to be more active in notifying you of deadlines and of communicating with you, and they're figuring out the best ways that they can do that, whether that's through email or it's through other types of messages that they can give you. So their goal is to that's not going to be the only, I envision that's not going to be the only route where you're going to find out what your renewal date is and stuff like that. So, but yeah, when they start to update the roster and make some changes, that's hopefully will happen soon.
If an accredited representative leaves the organization, does the representative have any obligation to report that to OLAP?
The organization primarily has the obligation to do so, but if for some reason the accredited representative doesn't think the organization will do so, they should report it. And there's nothing, I mean, it's simply, quick. It could be a phone call, it could be an email, just letting us know that you are leaving the organization.
Will accredited representatives within a particular organization that now must renew, will they be required to renew simultaneously with that same organization?
No, I think we had a question earlier. So renewal of recognition and renewal of accreditation are separate. So because organizations are generally going to be on a 6-year term, reps are going to be on a 3-year term. Now, conceivably, those terms might line up someday, and you might have to apply for renewal of your rep and your organization at the same time. But generally speaking, if you have currently accredited representatives, their renewal date is not tied into your renewal date of recognition. So it's going to be all different dates. And that was, I mean, in the proposed rule, we did have it all tied up and connected, and we received a lot of comments where that seemed to be unworkable for a lot of organizations. So in the final rule, that has been separated, and you can sort of see the justification for that in the supplementary information to the rule.
In the past, a number of organizations have referred to accredited representatives as BIA accredited reps. Is there standard language that we expect to use going forward, OLAP accredited reps or DOJ or EOIR? Do we have a recommendation at this point?
We do not have a recommendation. At EOIR, we've never referred to them as BIA accredited reps or DOJ accredited reps. I think that's sort of something that's been happening out in the public, and for various reasons, as it's sort of a way to describe your authorization. That might be something that you would want to inquire with OLAP when they take over the program, if there is a certain way that you should be referring to yourselves and your reps. So that could be something to discuss with them. But we don't endorse any particular terminology.
Is there a policy or best practice for fee waivers?
No, I mean, and the rule is not going to tell you what to do in that situation. And I think it depends. I mean, your different localities are going to have different levels of income and a different clientele to know what to set a waiver at. And that's going to be a judgment call for your organization. I think what the rule does provide, which the current rule, a lot of people have found a problem with the nominal fee restriction and trying to sustain an operation. This rule doesn't have those kinds of restrictions. I mean, it requires you to primarily serve low-income and indigent populations, but it doesn't put caps on your fees other than it has to be at a rate meaningfully less than a private immigration attorney. But that differs from locality to locality, and we can't tell you what to do there.
Okay. So the next question asks, if a recognized organization submitted an application for an initial accredited representative this year, will the individual be approved under the existing or new regulation?
So I'm presuming we have a pending application. Okay, so anything that's pending with the board currently, they may rule on it before the effective date. If they do, you're fine. That accredited representative should go on practicing. And they're going to be subject to the new rule once it becomes effective. If the application is not decided by the board before the effective date, the pending application will be transferred over to the Office of Legal Access Programs. They'll review the application and decide whether to grant accreditation or deny it. They might have some discussion with you. At that point, the accredited rep needs to meet the requirements of the new rule. So that's why the Office of Legal Access Programs might come back to you and discuss some issues that need to be addressed in the application because of the differences. But then they could accredit the person after those issues are resolved.
Okay. So the next question is, when renewing recognition and applying for an additional location, is there a place on the new EOIR 31 to list additional locations, or is a separate 31 required for each additional location?
No, there will be a place on the new form to list the information for the new organization. I believe there's a place for, it's either 1 or 2 locations. I'm not quite sure how it looks at this point. At least 1. There's going to be a space for 1. If you have additional ones, or if you have like 7, then you're going to need to just submit some additional attachments. You don't need to submit 7 31s to do that.
Okay, just one moment.
Yeah, just one space.
Yeah, we have it. I think we had it like 2 boxes. Yeah.
Okay, so the questioner represents an organization that would like to provide weekly presentations and intake at local parishes. And they will not have satellite offices, but will use the parish space twice per month for a few hours to give information and consultations. But all the information paperwork will be maintained at the central office. Does this organization need to explicitly note or otherwise seek recognition for these for the parishes in which they do their work?
I think you probably don't need to extend recognition to that location. You can, but it's not. You can. I would at bare minimum, I would note it on your application that we provide services at the central location and at these other locations that are not, you know, permanent locations, so to speak.
Great, thank you.
And I say that because on the annual summary of legal services provided, you will have to list where you've provided services. So if you do like a mobile thing, you would list, we provided mobile services on this one date or whatever it is. So on that, it's going to ask you where have you been providing services that are your location, your office locations, as well as any other kinds of locations.
Okay, so we have another question that pertains to the issue of multiple locations. So they refer to page 92359, which refers to, and I quote, through mobile or technological means.
Mm-hmm.
And they just ask for more explanation on what that might refer to.
I mean, so basically this is sort of recognizing that, you know, people are providing services in multiple ways. And in some of these instances, you're going to have to extend recognition to these locations. But if you're doing for instance, a Skype intake where the person is in a different location and you're in your office, then there doesn't need to be that, there's no recognition that usually needs to be extended in that situation. If you're doing something in a mobile capacity where it's kind of, I would say it is regular and consistent, that might be a situation where you might have to ask for extended recognition. But I would, at bare minimum, like I said, I would note where you're providing services if it's outside outside one of your office locations.
So the next question asks or states the new rule indicates that immigration status will be a factor in accreditation on a case-by-case basis. Can OLAP provide further guidance or provide further guidance on how it applies immigration status as a factor in accreditation?
So what I would tell you is to read the provision, the section discussing the immigration status provision. It does provide guidance there, and very roughly, I will sort of describe what the guidance is. And it's always a case-by-case determination, and what the rule says is immigration status will be considered if it prevents a conflict of interest, a potential or real conflict of interest. What that means in reality is what the supplementary information kind of describes, and that says, like, on a case-by-case basis, that will be determined. The two primary immigration status related issues to be aware of that the rule sort of describes as potential conflicts of interest are if you are in active immigration proceedings or in active proceedings before DHS to get a status revoked or terminated. Those could be potential conflicts of interest. And the other situation is if you have a removal order against you, then those are potential conflicts of interest for representation purposes. In those situations, the supplementary information says you are likely not to be accredited, but it doesn't preclude accreditation. And there are exceptions to the removal order issues and the idea of pending proceedings because these are all complicated terms. And so I invite you to read that section because it's clear as can be. But when those issues arise, those will be issues that OLAP will come back to the organization in all likelihood to discuss what's going on. But I will remind everybody that the rule does not, for character and fitness purposes, does not require an organization to look into somebody's immigration status or to provide information about somebody's immigration status to OLAP in order to get somebody accredited. That doesn't mean that under other laws, organizations as employers aren't required to determine whether somebody has the sufficient immigration status in order to be an employee. But for purposes of accreditation, an organization doesn't need to affirmatively look into that. A lot of the roadblocks that may come up are going to be when other information is provided to OLAP about an individual, and then that's when the questions will potentially arise.
And the citations for the sections that Paul's describing, to take a look at those so you see them yourself. The rule itself at character and fitness, where it talks about all the characteristics that go into that, is at 1292.12, the letter A, the number 1. So take a look at that. Those are the basic requirements for character and fitness. And then take a look at the discussion in the preamble. That's the supplementary information. If you're looking at the Federal Register copy of the rule, the discussion you want to read is at page 92352.
Okay, thank you. So the next question returns to the multiple location affiliate issue. The questioner represents a currently recognized organization that will have to apply to renew within 2 years of the final rule. Is it possible to extend that recognition to include a sub-office before the organization renews? Or if we want to extend or add a sub-office, do we have to do a full headquarters application?
I think in that situation, I would probably apply for renewal of the headquarters location and then seek extension. That's probably the easiest path because you would have just had to produce the only real information that you're going to have to produce that's newer would be your annual summary of legal services provided since January 18th of 2017, which wouldn't be that long of a period of time. So I would seek renewal earlier for that organization and not wait for the 2 years. But because otherwise you're seeking initial recognition for, well, you can seek to extend, you can also seek to extend recognition to that office too. You have that choice. I just think it would probably be easier just to seek renewal so you get it all over with before the 2 years. But you could also seek extension.
So the next questioner represents a nonprofit organization that does not have attorneys on staff and requests clarification on the clarification that the organization needs to establish a relationship with immigration attorneys for guidance and resources. And how does OLAP wish for this relationship to be documented as part of the RNA application?
So the rule does not provide that an organization has to have a relationship with outside attorneys or have attorneys on staff. It would be nice if it did have those things, but we understand for various reasons it's not practical for a lot of organizations to have attorneys on staff or to have relationships with other attorneys. The reason it would be advisable is because it sort of shows that the organization has the knowledge and experience to have non-attorneys on staff to be recognized. If you do want to establish a relationship with an attorney, which is good because it helps to show your bona fides for recognition, you would just enter into an agreement which sort of shows with the attorney, which shows under what circumstances you deal with the attorney, and it just sort of outlays the relationship, and that would probably be signed by the attorney as well, sort of vouching for the relationship.
Okay, so if there's a large organization that provides many services, of which legal services is one of them, is that organization supposed to submit the budget of the whole organization, or just the budget of the legal services unit or sub-office within the organization?
They can probably just provide the immigration legal services budget, but like there's some discussion in the rule about not everything that a nonprofit does is immigration legal services, but it might be immigration related. And those kinds of services where you might have like an event for immigrants and discussing various issues that might be relevant to them, those are important things for OLAP to know about that support your nonprofit bona fides, and that also support that you're primarily serving a certain population. So, having your entire budget for a bigger organization that has a lot of different things could be helpful in that regard. Or you can just, and if you can segment out your immigration legal services budget, then you could just do that too.
Okay.
I'd point out to the person that you'll see it described at 1292.11 and number 5, the letter C. That's where annual budget is described.
Okay. Thank you, Peggy. So the next question relates to estimated processing times for recognition and accreditation applications. Mm-hmm. Do we have anything that we're able to say on that?
Processing times? No, but I believe we are going to give some general, once OLAP gets up and running and starts doing it, they're going to give some general information about how long it's taking them to process applications. I will remind people that, at least for renewal, however long it takes to process the application is to the benefit of the organization and the rep, because you maintain your recognition and accreditation as long as you file the timely application. So if it takes OLAP a year to adjudicate, which it hopefully will not, you're recognized and accredited during that period of time. So you're good. The processing time becomes more of an issue for initial applications for recognition and accreditation, and those will be prioritized more because those people, we want to get them on board, we want to get organizations on board. So that's really the processing time to look at. The renewal one wouldn't be as helpful.
Okay. So we are about to conclude the webinar. We'll take one more question before we conclude. If you have questions that are waiting in the queue, which I believe we have several, would you please submit those to the PAO mailbox that's listed, pao.eoir@usdoj.gov, and we'll get back to you in writing on those. So the last question we'll take today is, can you elaborate on what inspection of other locations by the authorized officer entails?
It's sort of the general idea is you're going to the office, you're making sure that the resources are available for the organization. So when you submit your recognition application, you have to say, we have these resources available to our accredited reps, whether it's like a legal books, or more likely like a Westlaw subscription or something like that, where they have those minimal aspects. Inspection also kind of describes general supervision of the accredited representative and making sure, they're in line, what they're doing. So that's, as a general manager, and how you're keeping your files and all that kind of stuff. So it kind of relates to the overall control and supervision of an office and your representatives.
Excellent. Thank you. Thank you, Paul and Peggy, for that good information today. Thanks to all of you for joining us. If you have questions following this meeting, as I stated just a moment ago, please submit those to pao.eoir@usdoj.gov, and we'll work with our OLAP colleagues to respond. In the near future, the Office of Legal Access Programs will begin operating an email address and phone number that's dedicated to inquiries related to the RNA program. So that will be available to you, but in the meantime, please submit them to the PAO mailbox, which my office fields, and like I said, we'll work with our colleagues to make sure that we get you accurate information. I also wanted to share that later today we will be posting an recognition and accreditation training video that we put together a few months ago. That will be on our YouTube channel, and we will post a notice on the homepage of our website as well that links to that training video. It provides a nice overview of the rule and also focuses on certain elements that are especially relevant to organizations seeking renewal. So we thank you again for joining us, and that concludes our webinar.